From the Library of Congress in Washington, D.C.
Okay, I think we're waiting for one participant who's a couple minutes away, but we'll go ahead and start and he can join when he gets here. Welcome to the roundtable discussion for the Copyrights Office study on Section 1201 of the DMCA. Thank you for being here. My name is Reagan Smith. I'm Associate General Counsel of the Copyright Office. As you know, the office is conducting this study in accordance with a request from the House Judiciary Committee's ranking member in response to the Register of Copyright's testimony in a 2015 copyright review hearing regarding the impact and the efficacy of Section 1201 and the triennial rulemaking process. If you're here, you're probably familiar with 1201, but I wanted to provide a little bit of background into the statute and how it was enacted. 1201 is part of the DMCA, enacted in 1998, and in enacting it, Congress recognized that technological protection measures could be deployed not only to prevent piracy and other economically harmful unauthorized uses of copyrighted material, but also to support new ways of dissemination of copyrighted material to users digitally. So Section 1201 protects circumvention of technological measures employed on or behalf of copyright owners to control access to their works, known as access controls, as well as anti-trafficking provisions preventing trade in either services or tools of access controls or copy controls that protect rights to copyright owners under Title 17. Section 1201 also includes a triennial rulemaking process by which the Librarian of Congress, following a public proceeding conducted by the Copyright Office in consultation with NTIA, can grant limited exceptions to Section 1201A1's bar on the circumvention of access controls. The rulemaking is intended as a fail-safe mechanism through which the Copyright Office can monitor developments in the marketplace and recommend limited exemptions to prevent the restriction of fair and non-infringing uses. The rulemaking has expanded with each successive cycle. In the first rulemaking, the office received nearly 400 comments, and that resulted in granting of 2 exemptions. In the sixth rulemaking, which was concluded last October, we received nearly 40,000 comments. We considered 27 categories and granted 22 of the exemptions. Some of the categories in the last rulemaking concern the ability to access and make non-infringing uses of works such as motion pictures, ebooks, and video games, but others concerned access to copyrighted computer code and consumer devices ranging from cell phones to smart TVs, automobiles, tractors, 3D printers, and pacemakers. The Register said in her recommendation that while it's clear 1201 has played an important role in developing secure platforms for digital distribution of copyrighted works, it is also impacting a range of consumer activities that have little to do with the consumption of creative content. It also has become obvious that the regulatory process has become burdensome for participants in these rulemakings, especially when seeking to renew exemptions, and that the permanent exemptions, such as for security research, encryption research, or privacy, may have not adequately foreseen some of the developments since the DMCA. So this is the genesis for our study. We thank you for submitting your written comments, which we're looking at, and we're hoping that these roundtables will facilitate a deeper discussion. Kevin is going to explain the logistics and then kick off panel 1.
Good morning. My name is Kevin Amer. I'm a senior counsel in the Office of Policy and International Affairs here at the Copyright Office. Before we begin, I'd just like to go over a few logistical items. First, the roundtable sessions will be moderated by us here at the table. We will pose questions or topics for discussion, and we ask that to indicate that you would like to be recognized, you please turn your name card vertically. This will be familiar to some of you who've been to WIPO, and we'll then call on you. Just given the number of panelists and the number of topics that we are hoping to cover, we ask that you please try to limit your comments to about 2 to 3 minutes. We apologize profusely in advance. If you do go over substantially, we will unfortunately have to cut you off. We appreciate your understanding as we try to accommodate a lot of different viewpoints and hear from a broad range of speakers. We also ask, obviously, that you focus your comments on the particular topics that we provided in our notice of inquiry or to particular questions that we raise. Also, we've been asked if at the end of your comment, if you could please turn off your microphone because it avoids interference on the sound recording. Second, as you can see, today's event is being video recorded by the Library of Congress. Panelists, we've provided you with a video release form. If you haven't yet signed it, please do so and return it to one of us here at the table. In addition, as you can see, we do have a court reporter transcribing the proceedings. And finally, just before we begin, we'd just like to note that we may seek additional written comments in response to some issues that may come up during the roundtables. If we do, we obviously will provide a formal notice of inquiry. So at this time, I'd like to ask everyone in the audience to please turn off or mute any cell phones or devices that could interfere with the recording. Does anyone have any questions about logistics before we get started? Okay, great. Before we begin, I'd just like to ask my other Copyright Office colleagues to introduce themselves quickly.
I'm Abby Mosheim.
I'm Jason Sloan, Attorney Advisor in the General Counsel's Office.
And then if we could just go around the table, if you all could just please introduce yourself and your affiliation. We'll start with Mr. Adler. Oh, if you would turn on your microphone, if you would.
I think it was on, right? Oh, okay. My name is Alan Adler. I'm General Counsel and Vice President for Government Affairs for the Association of American Publishers, National Trade Association for book and journal publishing industry.
I'm Jonathan Band. I'm here on behalf of the Library Copyright Alliance.
Troy Dow with the Walt Disney Company.
Robin Green, Policy Counsel with New America's Open Technology Institute.
Aaron Lowe with the Auto Care Association. We represent manufacturers, distributors, retailers, and installers of auto parts independent of the vehicle manufacturers.
My name is Raza Pinjwani. I'm a Policy Counsel at Public Knowledge.
I'm Stan Pierre-Louis. I'm the General Counsel of the Entertainment Software Association, and we represent the U.S. video game industry.
George Slover, Senior Policy Counsel for Consumers Union, the Policy and Advocacy Division of Consumer Reports.
I'm Brian Weisenberg. I'm a law student at Stanford Law School's IP and Innovation Clinic, representing the Institute of Scrap Recycling Industries.
Jonathan Zook from ACT, the App Association.
Great. Well, welcome, everyone. So the first session is entitled A Relationship of Section 1201 to Copyright Infringement, Consumer Issues and Competition. And this session will explore the role and effectiveness of Section 1201 in protecting copyrighted content, and will consider how the statute should accommodate interests that are outside of core copyright concerns. So I think we wanted to start just by getting your view on asking sort of a big picture question and getting your views on the overall role and effectiveness of Section 1201. We had a lot of comments noting the different distribution models that TPMs have facilitated. And I think some other comments, and we had several examples of those. We had some other comments that I think question sort of the relationship between the legal protection of TPMs and the effectiveness of those TPMs. So I think we'd be interested just sort of in your general views about the extent to which the legal protections provided for TPMs provided under Section 1201 contribute to the effectiveness of technological protection measures in protecting copyrighted content. Mr. Band?
So I think as lawyers, we like to feel that we have an impact on the world. But I have a feeling that in this area, you know, the technological protection measures, to the extent that they've been effective in protecting the rights of copyright owners, it's because the technological protection measures have been technologically effective. We saw early on ineffective measures such as CSS that were very easy to hack. And you know, the technology to hack at DSIS was widely available. There was some hacking of it, some not. We now are, you know, in generations way beyond that in terms of the effectiveness of technological protection measures, especially with respect to all kinds of content that's in the cloud, and you have to, you know, behind very secure paywalls. And I think that the law has nothing to do with the effectiveness of those systems, certainly to the extent that one's worried about the general public. I'm sure some people hack into those systems from time to time, but what makes those work, and they work very well, is the technology, not the legal protection. And to the extent that one's worried about hacking and this unlawful hacking into these systems, you have the Computer Fraud and Abuse Act, and you have every state has its own anti-hacking statute, so there's this whole other array of laws that come into effect. So I think certainly as they are in the current form, I think the 1201 protections really have very little to do with the success of these technological protection measures.
Thank you. Mr. Adler?
I think it was recognized very early on, in fact, because this legislation, as we know, was the result of an international treaty that determined that legal protections were important for technological measures that were used to control access to copyrighted works. And that was not an accident, because I think the commonsensical proposition there is that having the ability to use locks, if you will, or technological measures to control access means nothing if there are no legal restrictions against people violating those locks or others in creating the devices or offering services to violate those locks. So when this legislation was enacted, it wasn't surprising that the House Judiciary Committee compared the use of this to, quote, electronic equivalent of breaking into a locked room in order to obtain a copy of a book. The idea here was all about access. It was to facilitate consumer access to works online because that would be convenient, because it was viewed that that would cut expenses, it would cut against the difficulties people have in finding these works. But the notion of bringing access online meant that access had to be secure in the face of all the ways in which online digital networks are susceptible to having people engaging in unauthorized activities. So we think that the legal protections were a necessary part of the notion that copyright owners could use technological protection measures in order to make their works conveniently and ubiquitously available online, and that's been a wild success.
Thank you. Mr. Zook?
Thank you, and thanks for having me here this morning. I may date myself a little bit, but I remember very clearly going to Egghead Software and buying a copy of a piece of software called Copy2PC. And that's how, in my younger unruly days, I copied software that I wanted to use, because it took creating copyrighted material to respect it in my particular case. I think the real purpose of the legal allowances and the legal prohibitions that 1201 offers is taking the technology out of the mainstream. It's not an all or nothing proposition. There's still going to be hackers, there's still going to be people that gain access to technology, but the widespread acceptability of that technology, that I can just walk into a Best Buy, for example, and buy software to break encryption, is, I think, what really is changed by the legal provisions that are put in place. So that's the connection. I think it has to do with numbers more than it does a sort of binary connection that between the two, if that makes sense.
I think Mr. Panjwani was next.
Thank you. When the WIPO Copyright Treaty was adopted and the United States was considering enacting the Digital Millennium Copyright Act, the consideration, I believe at the time, I wasn't there personally, was that there was a necessity to provide protections for rights holders in order to encourage them to provide digital goods and to distribute them online. One of the things we have seen is that DRM is not necessary for a number of business models, and business owners are entitled to choose how they wish to distribute. But we've seen the adoption of iTunes taking a DRM-free stance. We have seen CD Projekt's GOG.com game distribution platform sells both classic and newer releases without DRM. The Tor book imprint also releases ebooks without DRM. In the last 7 to 10 years, we've seen a move away from the assumption that DRM is absolutely necessary to have a digital economy. Considering that Section 1201 takes that assumption and then burdens the public's rights to engage in non-infringing uses in order to provide these protections, I think it's worth re-engaging in a cost-benefit analysis of to what extent do we still need these very high barriers in order to encourage digital distribution. Beyond that, I think it's worth talking about the fact that how effective 1201 has actually been in curtailing digital piracy, which is something that Congress explicitly called out in its legislative history as a reason for enacting Section 1201. In our comments, we pointed to a number of statements by various copyright industries decrying the level of piracy that is occurring online and digitally. And while I know some folks have responded by saying that, well, we need to look at the digital markets we've created. The content that has been allegedly made available by circumventing DRM and that is available in these marketplaces is the same. It's not separate. And I think separating these two sort of conflates correlation and causation, that because of DRM we now have digital markets. I don't think that's necessarily true.
How do we sort of get at that? I mean, in your experience as I'll open this up to everyone, as practitioners, is it your sense that 1201 actions are relatively common? Is this, I mean, I think we had some disagreement in the comments as to sort of how commonplace 1201 actions are. I'd be interested in your thoughts on that, or to pick up on the previous question. I think Mr. Pierre-Louis was next.
Thank you. In about a month, ESA will be hosting the E3 trade show, which is the world's premier video game trade show, where you've got consoles with new capabilities, new games and software. All that's made possible because of the twin goals achieved by the DMCA. When it was passed in 1998, the thought was we want to expand consumer access to broadband and to new technologies. And one of the ways we encourage that is by getting copyrighted content online and on other devices. And part of those twin goals involved 1201. We've seen that growth, which makes not only our trade show, but our industry a growing one, 23.5 billion now, the largest of the media companies and industries. And that happens because we know that our investment in our technologies and in our software and in our copyrighted content will get protected. When we're talking about various companies deciding to issue certain content DRM-free, that's a choice. 1201 is not a required statute. It's one that says if you implement this technology, it will have the force of law if someone tries to bypass it. But you don't have to use it. And we've seen many models, even within our industry, of people putting out games that are free to play and freemium models. And so we've seen the various models win out because different games and different companies have different goals. It doesn't mean one is mandated, and certainly there's no tech mandate in it, but I think if companies decide to go DRM-free, that's certainly not only allowable, but that's another way to access consumers.
Picking up on Kevin's question, in your industry, are you aware of instances of using 1201 as an enforcement, either in courts or prior to litigation, to protect the integrity of the DRM?
The good news about our industry is we've had a lot of success, particularly with the newer console models, in preventing that access. And so we've not had to rely on it in terms of legal claims, but we know that having it as a backstop protects us. We are a U.S.-only trade association, but we know that internationally we've had that success as well.
Thank you. I think Mr. Dow was next.
Thank you. So Mr. Ban talked about that there appeared not to be any direct correlation between the legal protections and the advancement of the goal of making material available digitally online, and the real value was in the technology itself. And I think that there is real value in the technology itself. And if you go back and you look at the NII white paper that made the recommendations that led to the adoption of the DMCA, it was very explicit in saying that in this new environment, that copyright owners would look to technology to protect their rights, and that would be a very valuable tool in terms of helping to promote the growth of digital commerce. But that technology alone would be insufficient to meet that goal, and that legal protections alone would also be insufficient to meet that goal. And it was the combination of the two that we're going to be required to meet the objective of encouraging people to sort of jump with both feet into a new digital environment in which content in a very high quality was put at risk. And I think the experience has been that that's what has resulted from the DMCA, that people have relied on the legal protections combined with the technological protections to get into these businesses with both feet, perhaps more quickly than otherwise would have been the case. I know that the availability, the WIPO treaties and their discussions, the DMCA, were directly relevant to the adoption of CSS as a protection for DVD. It was what led to the introduction of the DVD, which became the fastest growing consumer electronics platform up to that time in history. Jonathan is right that technology was hacked and that there were tools available to defeat it, but that's also what spawned much of the precedent that we have right now on the DMCA is in enforcement litigation under the DMCA dealing with those things. And it's not, and the objective was never to say that these technologies would be hack-proof or that there would never be anyone who would be able to access the tools to do it or that would be able to figure out a way to do it, but that you would keep these things out of the mainstream. And that's exactly what that litigation had the effect of doing. And, you know, Mr. Zuck talks about going into the Best Buy and being able to buy hacking software. When we were in litigation with 321 Studios over CSS hacking technology, that was exactly the issue, was that you could walk into Fry's and Best Buy and buy consumer-friendly hacking technology to rip DVDs. And the litigation that was involved there didn't remove the ability to hack DVDs, but it did take that activity and put it at the fringes while leaving a channel in the mainstream that helped to promote the availability of these new business models. Now, in the last 15 years that I've been involved in this from a business side, I've been at the intersection of the law and sort of the business considerations, and I can tell you that the availability of these legal tools has been directly relevant to the decisions to get into these markets, whether it was the development of AACS as a next-generation standard for the protection of high-definition digital content, whether it's the willingness to get into the market for 4K, whether it's the willingness to get into the market for over-the-top television and authenticated television to allow people to do streaming. The DMCA has been a factor in the willingness to engage in all of those things, and so I think it's, from our perspective, has been both necessary and successful.
Thank you. Mr. Slover?
So in our experience here, it's not been the intended uses of the technological protection measures in Section 1201. It's the overbroad uses, which I think were probably not intended or certainly not fully envisioned in 1998. It's, you know, we heard the metaphor a minute ago from the House Judiciary Committee of breaking into a house in order to steal a book. I think of another metaphor, which is my wife has baked a cake which she intends to take to church on Sunday, and my teenage son is hungry, and so she can either say, hey, don't touch that cake, or she can say, you know what, I'm so afraid you might touch that cake, I don't even want you setting foot in the kitchen. And I'm going to lock that kitchen door. You can't get into the refrigerator. You can't get into the cupboard. You're just going to have to go hungry because I'm worried about that cake on the counter. I think I'm hoping there's a way to sort of reconfigure and reconstitute what we're doing with 1201 so that we're really focused on the protection against infringement, and we're not capturing the interoperability and in my view, less closely related side benefits to industry of denying access to the software.
Connecting those two thoughts, Mr. Dow just said that 1201 has been both necessary and successful in the motion picture type of industries, and you've mentioned going sort of overbroad. Has 1201 played a role in protecting or any sort of useful role in the markets for 3D printers or software that anyone's aware of? Or cars?
So, yeah, we take it sort of a different place. I mean, what Mr. Slover said is very clear from our industry. We're about the automotive aftermarket is about a $350 billion industry in this country, and that industry provides choices to consumers in auto parts and where they get those cars serviced. And we're seeing the use of software on virtually every component on a car nowadays. And those components, some of them, we're not clear whether they're there for functional purposes or simply to make it difficult for people to produce parts to work on their vehicles. And we're seeing the use of the 1201 as a way to keep our industry out of being able to reverse engineer and produce parts and even service those vehicles. So we see a pretty broad impact on our industry going forward, and even currently we're seeing more and more parts which is with chips on them that are making it difficult for our industry to operate in the aftermarket.
So I think we're going to go with Mr. Weisenberg, then Mr. Zook, Mr. Band, and then Ms. Green, and then I think we're going to go on to another question. So Mr. Weisenberg.
I just wanted to quickly piggyback off Mr. Slover here and answer your question, Kevin. Example of someone using the DMCA or 1201 specifically to go after someone or file a claim. Last year, when ISRA was here asking for a 1201 exemption for phone unlocking, TracPhone's response was, we rely on 1201 to protect our business model, and we emphasize that that's not a copyright interest, and we're grateful again for the Copyright Office for recognizing that fact. And that kind of bleeds into another topic. I don't want to get there just yet, but just in case you need another example, that's one.
Okay. Yeah, and definitely we're going to try to explore some of these competition issues later on in this panel. Mr. Zuck.
Thank you. Yeah, I don't want to be accused of 2 bites of the apple or smuggling a file in a cake or anything like that, but some of the questions have evolved as we've gone along here, and I wanted to address a couple of comments. One is the notion that there's other business models that don't involve DRM, and that's certainly the case. And I think it's important and worth mentioning that the people that make use of DRM don't like it. It's not enjoyable to go through the process of trying to use technical protection measures on your products. It increases consumer support costs and everything else. It's simply been a necessary tool in preventing piracy. And I can say that it's certainly been a very successful tool in the context of software as well. And in the app market that I represent, the distinction between software and content is becoming continually blurred as well. So TPMs are used not only for the software itself, but also the content that's embedded in software where some of the piracy occurs. If I've got an app that's teaching you yoga positions or something like that, sometimes the piracy involves pulling the content out of the app and repurposing it in another app. So TPMs have proven useful in the software market. And then the final point is this notion about it expanding beyond its original intention. And I feel like that comes up over and over again. And in this context, I always remind everyone I'm not a lawyer, but it's my understanding that where those things have been adjudicated, they've come out in favor of a more restrictive interpretation of the DMCA. So I mean, whether it's garage door openers or printer cartridges and things like that, I think there's some fairly strong precedents in place to suggest that it should be focused on copyright infringement, and the jailbreaking legislation is another example, I think, of where the system worked to modify the environment in which people are getting overly experimental in the use of 1201. But none of that, I think, undermines the value that it's played in what has been a very successful market, and I think we should be very cautious about upending that.
Thank you. Mr. Brand?
Going back to your question about, the number of cases, and I think you're right, there have been relatively few 1201 cases, certainly relative to the number of, let's say, 512 cases. And it's always important when we're talking about 1201 to also keep in mind that it's part of this bigger construct of the DMCA. But one of the reasons why there's been relatively few 1201 cases, it seems to me, is that it's really broadly drafted. It talks about not only the act of circumvention, but it talks about trafficking. Then there's also 1201B. The early cases, went very strongly in favor of rights holders, and so there was very, there just hasn't been a need for the litigation because it's been so broadly interpreted. So then the action really has shifted very much to the rulemaking because there you have all these people who are adversely affected, and if you're adversely affected by the DMCA, I mean, you have two choices. You could sort of go ahead and engage in the activity and hope that in the event of litigation that you'll end up with, you'll end up in the right court, right? That you'll end up in the Federal Circuit, I guess, or the Sixth Circuit as opposed to the Ninth Circuit. But good luck in making sure that that happens. If you're on the defendant's side, you don't really get to choose where the action is filed. And that's one choice, or the choice is to go to the rulemaking. And so much of the activity and the energy is on the rulemaking side because, at least there is a rulemaking. So we're glad for that, but that's why, because the DMCA is so broad and has been interpreted so broadly by some circuits, that's pushed all the activity and the focus onto the rulemaking side, and that's why so many of us are so intent on trying to get the rulemaking to work better than it is.
Thank you. Ms. Green?
Thank you. I was actually just going to say some of what was just stated with regard to the reason why there is not a tremendous amount of litigation and the fact that there have been favorable decisions in previous court cases. What I do want to note about that, though, is that it is impossible to calculate the chilling effect that those previous court cases, even though they were ruled on favorably, has had on the market. Entrepreneurs who are just trying to enter a marketplace may not want to take the risk that all of the efforts that they go to develop a new product, to innovate, and to launch it in the marketplace may be for naught as a result of litigation, even if they might eventually win that litigation. And so that is a great concern. And then to the extent that it has been pushed, the litigation has been pushed to the rulemaking process, I do still think there is a chill in the marketplace, and a chill specifically in activities that are very clearly not related to copyright infringement, such as security research. And the burdens of that rulemaking process, which I know we'll be discussing later, I think do oftentimes go outside of the question of the effectiveness of TPMs in helping the marketplace, and in fact, sometimes favor the chill of that type of competition.
Thank you. So turning from the effectiveness and the role of the current law, I think we wanted to explore a little bit some of the proposed changes to 1201, and really one of the central points of dispute or disagreement that we saw in the comments is this idea that there is or should be a nexus within 1201 with copyright infringement. We had a large number of comments supporting the model, obviously, in the Unlocking Technology Act that's been proposed that would limit circumvention violations to those undertaken for the purpose of infringement. In response, we had several comments saying that that accessing a copyrighted work for purposes of consumption alone may not implicate an exclusive right, and indeed that type of activity is really one of the foundational reasons why Section 1201 was enacted. So I'd like to sort of explore that debate a little bit. What are your views as to proposals to incorporate a nexus to infringement within 1201? Mr. Adler.
Well, there is a nexus to infringement in 1201, but it's not in 1201.
Oh, microphone, please.
There is a nexus to infringement in 1201, but it's not in 1201A. 1201A is about access controls, and access is not part of the exclusive rights of a copyright owner under 106, but obviously access to the work is the threshold issue with respect to whether or not uses of the work that implicate the exclusive rights are going to occur. If you look at the way Congress structured 1201, 1201A was designed to deal with the question of access independent of the issue of infringement because access to the work, again, was the question about whether or not consumers were going to be able to exploit the marketplace and whether there would be a marketplace of these works online to exploit. When you look at 1201B, 1201B doesn't address the question of circumvention of technological protection measure that protects rights of a copyright owner under Section 106 and Title 17, specifically because it recognizes that those rights are themselves subject to exceptions like fair use. But that's why those two questions have to be looked at differently. The issue of access is not about infringement. And to the extent that Congress did seek to allow copyright owners to utilize technological protection measures to deal with the issue of infringement, that was done in 1201B, where the balance was struck in recognizing limitations and exceptions like fair use, while still suggesting that even though there already are remedies in the law to deal with infringement, technological measures can still help a copyright owner be able to deal with that by at least making sure that to the extent they do use technological protection measures to protect exclusive rights, that those are not subject to a marketplace that's rife with availability of the means to circumvent those measures.
Thank you. Mr. Band?
So I think the premise of 1201A was, Alan is right, it's about access, but it's about access, I think what everyone had in mind and everyone thought they were talking about was access to something you hadn't paid for, right? I mean, it was, the idea was, it was like getting, and the people were talking about sort of getting access to cable television, that, to getting access to the premium channel that you hadn't paid for. That's what it was. That's what I think everyone was really had in their mind. And certainly not the situation that Mr. Lowe is dealing with in the automotive context about a person not being able to access his own software in his own car for the purpose of making sure that he doesn't pay marked up prices for repair parts. And that was not at all what was contemplated. Now, one can debate what the words say and how they properly should be interpreted, but I think it is fair to say that there's no policy reason within the confines of the Copyright Act or within the confines of section of Title 17 for there to be any restrictions on a person's ability to access their own property, their own copies. It's one thing to say I shouldn't be able to access something I haven't paid for, but if I've paid for it and it's in my possession, why should there be a legal framework that protects my ability to access that? And so that's why we think the Technology Unlocking Act makes sense, and that's why, and whether it's through a statutory change or through a much more liberal application of the rulemaking in the case of at least software where we see this problem most pervasively, we would be able to sort of simplify your work significantly and not have the DMCA basically regulating the entire U.S. economy.
So earlier we heard about the various types of digital distribution, and is your theory that 1201 should be limited to, consumers should be able to access what they have paid for? Does that depend upon an understanding of ownership of the good as opposed to a rental model? I mean, I think some of the things that come up in the rulemaking is a fear that consumers may have paid for a penny but want to access a pound. Does your theory does it matter whether you actually own the refrigerator or the book as opposed to lending or leasing or a subscription model?
I think there's various ways to slice the loaf, and certainly if when we're amending 1201A, I mean, you could. I think the best way to do it is to simply require a nexus to infringement, so that if there's really no possibility of infringement, it's not within the scope of the law. It's like when you're drafting a statute, you can either draft it, make it really broad, and then start having all kinds of carve-outs, and you're never going to have enough carve-outs, but it's sort of like who shows up at the table, who has the enough lobbying strength to get a carve-out, and that's unfortunately the approach taken in 1201. The alternative is you have a narrower bill, more tailored bill, and you understand that there might be some leakage. And then if there's leakage, then you maybe make amendments to take care of those leaks. And I think that that's a better way to approach it. But, if we're not talking about there's other ways of doing it. I mean, you could certainly simply, you could carve out software or software, embedded software. I mean, there's all kinds of different ways that 1201 could be amended. Again, I think a nexus to infringement would be the best way and the simplest way, but there are certainly other ways that are that would be less effective, but it would be better than the status quo.
Thank you. And so could I just to follow up, so would a nexus to infringement encompass this, the sort of paradigm scenario that Mr. Adler mentioned, where someone is accessing a copyrighted movie to watch it? Would that?
Yeah, the problem
would that be a nexus?
Requiring a nexus.
Oh, microphone.
The problem with requiring a nexus to infringement for 1201A, where you're dealing with the issue of access, is that it fails to recognize that access to a work has its own independent economic value, whether or not someone is going to infringe as a result of that access. For example, we hear all the time in the book industry that the difference between the use of printed books and digital books in digital formats, whether they're in e-books that you have, that you're looking at in a device, or whether you're actually reading a book online, is the fact that reading a book is not something that actually exploits one of the exclusive rights of a copyright owner. That's true. But the purpose of putting a book on the marketplace, the purpose of actually creating a work of original expression in book form, is ultimately to have people read it. And that's where the economic value is. So the notion that the only way rights holders can protect access to their works or control access to their works online is if they are able to show that the means by which they do it is directly related to addressing the issue of infringement, neglects the whole notion of what the real value of these works is in the way they're used in ways that don't involve infringement at all.
Thank you. Did you want to respond to that quickly? Or?
I don't want to monopolize, but I mean, a lot of it could be taken care of conceivably in the drafting, but even if we're not, it would seem to me that if I let's say, rent a book, right, and I'm entitled to it based on my rental fee to have it for a week, and I fiddle with the software so that I can keep it another week, that seems to me that might get into this area of the kinds of, what we may be talking about, that it conceivably could be still subject to 1201A, especially to the extent that in order to continue reading it, I need to continue making copies of it, RAM copies and so forth, that are of more than of more than a transitory period. So, I think even in that case, it would conceivably, depending on how you draft it, it would still be within the the scope of what I'm thinking of.
Thank you. Mr. Dow?
So Alan is absolutely right. The absence of a nexus to infringement in the statute is quite deliberate. In fact, the proposals like the ones you find in the Unlocking Technology Act are not new. Those were proposals that were made at the time the DMCA was considered, and they were rejected for a variety of reasons, including that really to have done that would have made Section 1201 rather duplicative of Section 106, and that was not the objective of the statute. What Congress saw at the time that they did this was a world in which you had the type of scenario that Alan just described, where the value the benefit to the consumer and the value to the copyright owner is derived from access to the work, not necessarily from the exercise of the Section 106 rights. So the ability to access a work, whether it be a book or a song or a movie or any other form of expressive work, doesn't require you to copy it, doesn't require you to distribute it, doesn't require you to publicly perform it, but that the value is derived from your ability to access it. At the time, the thing that was talked about was the Celestial Jukebox. We've sort of gone to that model across the board for different types of expressive works, and Congress had that in mind. That's what the intended result would be, and the fact that we are quickly and continually moving in that direction is sort of a testament to the way that it was structured. That's it.
Thank you. Mr. Panjwani?
Thank you. We believe that a nexus to copyright infringement within 1201 cures a number of the issues that have manifested over the last 5 to 10 years, such as the issues of access to consumer devices that have software embedded within them and a variety of other competitive issues that have been implicated. But taking this back for a moment to the discussion we've just had on the right of access and where it exists in the copyright law. Section 1201, it sounds like what we're hearing here is that Congress intended to create an exclusive right of access for authors. And I don't think we should be afraid of considering this in terms of, well, if we have a nexus of infringement in 1201, then what happens to the right of access? And I think then we should have a debate on the right of access rather than on a prohibition on circumvention. If Congress wanted to create a right of access, they could have put it in Section 106 with the rest of the exclusive rights granted to authors of copyright-protected works. Now, again, looking at some of the legislative history and the text of the statute, there's no discussion of, well, we wanted to create this right of access. It's we want to create incentives to enter digital markets, and we think that this is a necessary step to incentivize entry into digital markets. And I don't think that, a explicit right of access was contemplated at that point. In fact, the WIPO Treaty says, we want to have adequate protections for technical measures that are employed by authors in the protection of their rights granted under, this treaty, which we would then read in the case of the U.S. statute under this title, which is 106, which is reproduction, distribution, public performance, and so forth. In particular, I would say, the examples that that Mr. Ban and Mr. Adler were just discussing, I think you perhaps underestimate the creativity of plaintiffs' counsel and their ability to identify a violation of 106 in any of these given particular instances where you're afraid that copyright infringement does not get at the behavior. There may be an access to a copy. Well, where did the copy come from? Is the copy lawfully possessed at the time of the access? In the case of a rental, was it sold? Well, it was rented. After the rental expires, do you still lawfully possess that copy? So I think there are a number of ways of solving this issue that don't require such a broad prohibition on circumvention that burdens all other non-infringing uses.
Can you speak to Mr. Adler's distinction between access control prohibition of 1201A versus copy controls in 1201B, the anti-trafficking prohibitions? I mean, that seems like statutorily they've made that difference, and we could rely on that as opposed to creativity of plaintiffs' counsel.
Mm-hmm. It's been our position that the anti-trafficking provisions distinction between copy protection and access protection as far as implementation are largely indistinguishable. That a TPM used for access control is a TPM used for copy control often. And we've approached that in the exemption process as addressing them more or less as the same.
Because you're seeing the merged use of controls in the industry.
Right. In practice, while the statute recognizes them as two separate types of control, in practice we see them implemented as more or less as the same.
Thank you. Mr. Pierre-Louis?
I just wanted to add that in our industry, that's not the case, because you have console manufacturers and you have publishers who produce discs. They have to interoperate, but they do have separate types of access and copy controls within them. So in our industry, we've seen the benefit of having both of those available. It's important to recognize that we're not trying to identify infringers. We're trying to identify and cultivate consumers. And so all of these things help us do that. And so access to the work becomes an important way of distinguishing the different uses users want. Some want it on mobile, some want it online, some want it on a disk and a console. And I think all of these rules allow us to play within that framework and meet customers where they are. This is not academic for us, this is business. And so, making a nexus to infringement in many ways harms the consumers. Because right now, and I think this is the correct interpretation of law, possession of the work is not what's infringing, it's the various uses some may make, and now we're trying to implicate more on consumers there. I think it's important to recognize that access control allows them to make uses, and that's what we're trying to cultivate.
Thank you. Mr. Slover?
Yes, I wanted to go back to your earlier question about ownership versus other models of rental or so forth. I think ownership is the core focus, the rights of a consumer who owns a product to be able to use it. I think you should be careful, ownership can be written around by lawyers so that what the consumer thinks is ownership really isn't ownership. So I think it needs to be broader than just a legal definition of ownership, but it's the concept of the consumer's rights and dominion over the product that they've paid for, that they have. And I think it's a useful starting point is to try to, if possible, clear the smoke around the technology and sort of the complexities of software and everything, and try to think of when the DMCA was passed, there was sort of a recognition we need a new legal construct to bring the traditional copyright protections into the digital age. Well, I think on the other side, we need a recognition that the tried and true incidents of ownership should still have value and presence in the digital economy. So, for example, taking the auto software situation, if it was something that a consumer used to be able to do in his garage with a screwdriver, that was not a copyright issue. It was not an infringement issue. It was not an inappropriate use. If the same thing in the new world requires getting access to the software in order to be able to make an adjustment, the fact that there's a technological protection measure on top of it should not change the ultimate calculus and objective.
So the Copyright Office is separately undergoing a study on software and embedded devices, and I'm wondering if what you're saying, or if there could be some consensus around treating software in these embedded devices differently than TPM's protecting expressive works, if that might be another way to slice it rather than nexus to infringement.
Well, I'm not a copyright lawyer, and our experience at Consumers Union, our point of entry into all of this was really the mobile phone unlocking effort that we helped lead. So I can't speak too definitively to the broader issue. I do see sort of a big picture conceptual distinction between the core creative works and access to books and movies and songs on the one hand, and products that you now can't use unless you have software that's functioning inside them. So what's brought us in, the concern that we saw, was that internet software-enabled devices, both in the Internet of Things and then the things that just sort of operate internally. But I wouldn't want to put my finger on the scale of some of these other issues.
Thank you. Mr. Adler?
Yeah, I just wanted to make 2 points. One is, if I understood Mr. Panjwani correctly, he suggested that an alternative approach by Congress would have been to include access within the exclusive rights enjoyed by a copyright owner under 106. And I would only have to assume that the constituency that he represents and that, for example, Jonathan represents in their criticism of 1201 would oppose vigorously such a notion, because that would lend the idea that access itself had the attributes of a property right, which is what exclusive rights under 106 really are about, rather than this being a question of whether or not somebody who is going to use their works in a marketplace manner, making them available to people, but expecting to be able to assert certain terms for condition of availability and use, would be able to control that in the first instance by controlling access to the work. And then the second point I was going to make is that, just to be clear, I was kind of concerned about seeing the emphasis in the notice on talking about 1201 outside of core copyright concerns. I'm not sure I have any real grasp of what that phrase, core copyright concerns, actually entails, but it would be a tremendous mistake to equate that with the notion of a nexus to infringement, because obviously copyright concerns drive far more than simply the notion of whether one of these specific exclusive rights is violated. We've talked, always talk about the incentives to create works of original expression in the first place, which is driven to a large part by the private incentives involved with the benefits of copyright. And I think the discussion we had a little bit earlier about access relating itself to the value of using a work without infringing it or without in any way implicating the exclusive rights of the rights holder, that is a core copyright concern. And we shouldn't treat that notion very narrowly so that we only think that core copyright concerns arise when we're discussing about infringement.
And I think that goes really to the point Mr. Slover was making, and I'd be interested in people's thoughts about it. I mean, I think what this debate seems to be sort of struggling with is there a way that 1201 could be reformed that would include things like accessing, circumventing a TPM to watch a movie for free, so that would be included, but things like garage door openers and printer cartridges would be excluded. One proposal short of a nexus requirement that was raised in the comments is this idea that I think Reagan's question asked about, which would be a permanent exemption for software essential to the operation of a device. Is that something that would strike the proper balance? I'd be interested in your thoughts about that. Mr. Zuck?
Thanks. And yesterday at the Embedded Devices study panel, we had a swear jar whenever we mentioned 1201. So I don't know if the same applies today. But that discussion was quite robust yesterday, so I'll only briefly reiterate what I said yesterday, which is that the same kind of dynamism in terms of product offerings and things like that still applies to what is sort of loosely called the embedded software market as well. I mean, and so one of the examples that I used yesterday was TiVo, where the hardware was given away practically as a lost leader, and it was the embedded software and the services associated with it, which is where the company TiVo actually obtained its value. So I mean, there's some complexity about just having a broad brush approach to software that's embedded to devices. It would have to be a much more complicated wording in order to get at the distinctions that people want to make, so that you are excluding printer cartridges, but you're including the ability to have flexible hardware, subsidy models, et cetera, that are pretty prevalent in this market. So we certainly couldn't support anything that was just sort of a broad exclusion of embedded software into 1201. I think that would be a mistake.
Thank you. Mr. Panjwani?
A permanent exemption directed towards software embedded in consumer devices, I think, would be a good start. It would address a number of the overhang issues that we've come across in recent years, such as cell phones, jailbreaking, tractors, automobiles, and 3D printers, and so forth. However, I think it overlooks the fact that there are a number of issues that involve quote-unquote traditional media and expressive works, leaving aside the fact, that one could argue that software code is an expressive work and necessarily must be so to be protected by copyright. In particular, there have been a number of exemptions, and I guess we're going to go into this more with the process panel, involving where's the appropriate balance between access for fair use purposes, whether it's a documentary filmmaker, a narrative filmmaker, or an educator. And 1201 places a substantial burden on those uses as well, not just those of embedded devices. And I would also caution that any attempt to create a permanent exemption on software-enabled devices would instead turn into a fight over what exactly is a software-enabled device. And I'm sure we have enough creative lawyers here that we could probably spend years hashing out what the appropriate definition of that would be. The end result would be the litigation would be not whether a copyright interest has been violated, but is the thing at dispute in this particular litigation a device within the meaning of the statute? And that opens up a whole can of worms, I think.
Thank you. Mr. Pierre-Louis?
I think we have to tread very carefully anytime we're talking about these blanket exemptions. When we're talking about 1201, we're talking about software used to protect software of an expressive work. In our case, we're talking about software used to protect software of software, right? Because we are a software industry that does creative and expressive works. And so when you're talking about this blanket rule, you swallow the entire industry. On top of that, when we look at how our games are still being played on various platforms, but in particular game consoles, when you talk about consumer devices, game consoles are used for games, they're used for television, they're used for movies, they're used for all manner of distribution now because consumers demand it and our companies meet that demand. So we have to tread very carefully as we think about what that means because it implicates more than just thinking about a tractor. We're talking about the very devices that consumers are using to consume the content that we're making.
Thank you. Mr. Brand?
So, switching hats from the Library Copyright Alliance to the Owners' Rights Initiative, who I was representing in yesterday's roundtable, I think they would support an exemption along the lines of what you're talking about. I mean, conceivably a nexus or something along a broader limitation would be better, but this would be a next best, something that really does target the situation where you do have this embedded software. I think and conceivably, there could be exceptions to that exception for Mr. Pierre-Louis' clients. I mean, and I welcome Raza's suggestion that we could spend years negotiating that. Hopefully I would have a client in those negotiations. So that actually, my retirement, that would, be a nice trajectory towards retirement. But I think, again, sort of, just the bigger point is I certainly don't think that Congress, when it was talking about 1201, and I was part of those discussions, as some of the others around the table were as well, they really were not thinking about tractors. And the fact that we're talking about tractors and that's been in automobiles and that's where it's gone to does suggest that there is a serious problem here. And the fact that that the Internet of Things, we're talking about a world where all these devices are going to be connected, and they're going to be connected by software, and then there's going to be these implications for competition everywhere because of this statute. And so we need to say, okay, what do we, unless you want to, I mean, you're talking about how we went from two exemptions to 22 exemptions. Well, I think next year, in the next cycle, it's going to be, it's going to continue to grow at a geometric rate. And, it won't take very long before, the whole building will be working on 1201.
Thank you. I think Mr. Lowe was next.
So some of my points have already been taken, but I want to emphasize from our point of view, the parts on a car that used to be repairable using mechanical means now require access to the software. So we equate now the software to the parts, and once you take away that right to repair those vehicles, that becomes a really difficult issue for our industry. People who modify their cars in their garage should still have the ability to do that. And I think your suggestion is a good one to start out as far as giving that, some reasonability, rather, because these are not expressive works. These are mechanical functions that are now been taken over by software, including, windshield wipers now that used to be all mechanical. Now software might control how that windshield wiper is operating. If it's a patent, that's fine, but, the non-copyrightable function should not be allowed to be protected.
Thank you. Mr. Dow?
Just very quickly, I think some have talked about this exemption that you suggested in terms of embedded software. I think that your question, actually, if I heard it right, was about software necessary to make a device run. And I just, to me, I'm not quite sure how to interpret that, and I think it just sort of highlights how difficult some of the drafting would be around something like this. What comes to mind, and the concern that comes to mind for me, is thinking back even some of the early cases. Maybe the very first case under the DMCA was brought by Real Networks, and what was at issue there was an authentication sequence that in order for you to be able to use your device to stream a Real Networks, a file that was protected using Real Networks DRM, you had to authenticate the device to ensure that you were talking to a real server that would protect against copying of the content. And somebody had gone in and spoofed the authentication sequence in order to get around that process. And so in order, that was really software that was required to make that device work the way it was supposed to. I think in the entertainment field, a lot of what goes on has to do with authentication, right? If you want to use a DVD player, that drive has to authenticate itself to ensure that it's playing by the rules before you access the content. And so I just want to urge some caution about how some of these things that we talk about in one context really impact in a totally different context that would be problematic.
That's a good point, and I wonder if anyone else could speak to whether some of these TPMs or software are running on, both devices or protecting expressive content, as well as devices that are not. In the past rulemaking, we talked about jailbreaking a variety of things, and one of the testimonies there said, the software is the same no matter what the thing is. So whether 1201 should treat that all as protecting expressive content, or whether you can make a distinction if the software is running on multiple types of devices.
I think I understand the question, so I will try. So in our industry, there's the software authentication that happens with the game console. There's also, there are also servers where you're playing online, you can be streaming the content, you can download the content. All of those require different types of software in order to interoperate, because we're soon going to even have multi-device type, where you can go from one platform, multi-platform playing. All those require a lot of interoperability in software, and I think, as Mr. Dow was saying, it takes a lot of thinking about how those work before we get into rules. I don't know, for example, whether some of the software that operates the machinery that some others are talking about here has this other copyrightable function in it, but I don't know enough about that technology to say, well, that shouldn't count, right? And I think that's that's where we have to be careful to tread. We know in our industries we're protecting the expressive works, and so we can speak very definitively, but in some of these other areas, they are also doing things that are probably copyrightable, and whether you want to say it's a high level or low level, it's not for me to judge that. What is important is to understand that there are rationales behind each of our uses of software, and we've got to be careful in thinking about what we're implicating, what we're tripping over, because there would be unintended consequences. And notwithstanding Mr. Band's idea that we just go really narrow and we just fix the leaks, for us, the leaks are the business. You know, once they're out, they're out. And so it's important for us to be able to monetize that, but also to make sure that consumers are getting it in the ways that they want it.
Thank you. Mr. Zook?
Thank you. And again, I guess to understand your question, there's certainly software itself is I don't know if that constitutes an expressive work, but that, I mean that's where we are interested in making use of these protections. And there are a lot of different licensing models for the software itself, and so sort of protecting that dynamism, I think, is also really important. That it allows for different kinds of models for making software available to different communities, et cetera, and that kind of, so there's some price discrimination benefits, et cetera, to having dynamic business models, and I think that that's part of what has made my industry thrive so much. I guess I'd rather approach this from the other end. If we're trying to, since we have the 1201 exemption process in place, maybe a better reform is trying to streamline renewals, for example, that once you've identified something that is a clearly acceptable use, make it a lot easier to continue that use somehow, but continue what seems to be a working process through the Copyright Office to determine what are legitimate uses and streamline the process of their continuation, rather than trying to go through and predict legislatively into the future that we don't even really know what that'll be. I mean, right now, cameras, very often the firmware in the camera is what determines the functionality of the camera. So different levels of cameras that you buy have different firmware in them, and that's actually what determines their functionality because it creates manufacturing efficiencies, right? So the firmware ends up becoming really critical to the operation of the camera, but it also is a distinguishing characteristic of the camera as well, and I think that we want to allow that flexibility and the efficiencies that it creates. So let's look at this from the other end and streamline renewals of exemptions, for example, instead of trying to come up with a legislative fix that I think would be a morass and only, enrich Jonathan Band's law firm, right? I mean, to me, that doesn't feel like enough of an incentive to disrupt a system that seems to be largely working. I mean, we're looking at exception cases, and most of the litigation around those exception cases has come out in a way that I think we all agree was the right way. And so that seems to be a system that's working, not one that's broken. And I think that's, we need to keep that in mind. I mean, I as a copyright owner, I don't mind the default case being, the default answer, I said this yesterday, I don't mind the default answer being no, right? There's this notion that, wow, people are disincented to start new businesses that might infringe copyright because their lawyers can't assure them that it would be okay, that this creative use of getting around copyright law would be okay. And I think it's okay instead that the default answer is no, which it is in most cases. It's not that confusing what's legal and what isn't. And I think that we need to look at the exceptions hard and then find a way to preserve them into the future as a better approach, I think, than rejiggering the law.
Thank you. I saw one or two cards go up in response, so I'm sure people have some responses. Ms. Green?
Thank you. I just wanted to respond a bit to this idea, first about the idea that 1201 is meant to limit access, and that is rightly the case, and the idea that it's proper that the default answer should be no with regard to exceptions. We've spent a lot of time talking about the marketplace implications of the effectiveness or ineffectiveness of TPM measures. We have not spent a lot of time talking about the public safety implications of DMCA 1201, specifically with regard to the chilling effect that it has on security research. It was recently noted that there has been a significant increase and will continue to be a geometric increase in the amount of connected devices in the Internet of Things. And what we see is a tremendous obstacle that security researchers in particular need to overcome to ensure that whether it's cars or airplanes or refrigerators or TV sets or any of the other connected devices that we all use and depend on are in fact secure. And so when we set access as the threshold and say to security researchers that you can't breach access because that is an infringement on the purpose of 1201, as opposed to protecting the core intellectual property, as opposed to protecting against copyright infringement, I think what we say to the public is that market interests are more important than the public safety or the potential public health interests of ensuring that our increasingly connected world is in fact secure.
Thank you. I think Mr. Adler is next.
Well, I think with respect to those concerns, it's pretty clear that they have been addressed to some extent by Congress through original statutory exemptions with respect to security research, reverse engineering, and also every 3 years we revisit many of those issues in the context of the triennial rulemaking proceeding. But again, it goes back to the question of whether or not ultimately the issue of infringement becomes the tail that wags the dog of 1201. 1201 was a recognition that wholly apart from the issue of infringement, there was value with respect to access to a work that had to be within the ability of the rights holder to control. Otherwise, the rights holder would have little reason to expose that work in an online context for people to be able to access and use it without providing any value to the rights holder in return. And one thing that must be kept in mind as we discuss these issues is that courts have not had any difficulty whatsoever being able to dismiss the notion that fair use contains a right of access to a copy of a copyrighted work. It doesn't. It never has. The arguments in favor of why it should have never gained any real traction. One can understand why, because again, it would subject the notion of access as an independent venue of economic value to be limited only with respect to how that access related to the use. And if the use was non-infringing, whether fair use or not, but if it was non-infringing, you'd be throwing out the ability to control access. And that's really what 1201 was originally about and continues to be about today.
Thank you. So we have about 10 minutes left, so I think we're going to go around the table one more time to respond to this question to account for the cards that are up, and then I think we have time for maybe one more question after that. I believe Mr. Panjwani was next.
I wanted to respond to a couple of the prior comments. Regarding Mr. Zook's comment that the default answer being no is acceptable, I think the discussion that we're having right now about the essential software or embedded software exemption, I think highlights the danger of setting defaults at no. That the growth of all of these other issues shows that, we thought the default can be no because perhaps this is not going to be such an incredible implication on a vast range of economic activity. But it turns out it is. And I think it's worth reevaluating whether the default being set at no makes sense in light of all of this. I would also say that the examples of successes that have supposedly occurred are, for example, I'm assuming the Chamberlain case and the Lexmark cases. But for each one of those cases, there's a case, for example, like I believe 1201 came up in MDY v. Blizzard, and I believe it also came up in particular in the Real DVD case, where a court was faced with software that allegedly could be used for supposed fair uses. And the court said, well, I can't get to whether or not the use that's being enabled is a fair use because there's a circumvention happening here. So we never get to establishing case law on core copyright because of 1201. I will also point out that I think that, in response to Mr. Adler's comments, that access as a right in and of itself, that the comments regarding the passage of the DMCA is that we're creating this ancillary right of access for the purposes of discouraging and disincentivizing and preventing infringement of the 106 rights, not access for the sake of access itself. The fear was that digital goods are so easily reproducible, so trivially and so easily distributable in an online format that you need this additional protection to backstop 106, not as a right that stands in and of itself.
Thank you. Mr. Slover.
Raza just covered my point.
Okay. Thank you. Mr. Zook?
Yes, thanks. I just wanted to respond briefly to the public safety comment made earlier, that I think that it's just we important to recognize that there's public safety implications to tinkering with embedded software. And so again, if we bring public safety into the discussion, security isn't the only component of that. It's also how the software is being used and how the interconnection between software is being used, increasingly in medical devices and other areas where there's an enormous public safety issue associated with allowing people to tinker with embedded software. So I mean, we can have that conversation, but it's going to be much broader and much more complicated than I think people would hope that it would be.
Mr. Adler?
Well, I would just again point out, I mean, we talked about this at the very beginning, that for the models, for example, in the industry I represent that are most important, things like library e-lending or subscription on demand or print on demand or being able to rent a work on demand. The issue there is about software being used to provide access to the expressive work that's protected by copyright. And we shouldn't let the difficulties created by the fact that software has a dual identity as both a copyrightable and protected work in itself, and the fact that its functionality is used for purposes of controlling access to a separate and distinct expressive work, to place those expressive works in a position that Congress had not intended. I again respectfully disagree with the comments that were made before about the right of access being something that was considered only with respect to the issue of trying to reduce online piracy. It was not. It was specifically the case that Congress sought to be able to create online markets for copyrighted works. And that was the reason why access had to be subject to some degree of control that was separate and distinct from what you intended to do with the work once you acquired access to it.
Thank you. Mr. Band?
So I'll respond to Alan's previous comment, not this last comment, but the issue, at least where I see the big problem with 1201A in this access point is, again, it's access to something, whether you have, it's one thing to get access to something to which you don't have a legal right to access, meaning you don't lawfully possess that item, as opposed to something that you've paid for and that you have lawful access to, and your ability to get inside that. And this really, you know, and this really gets to the point about security testing and so forth. So yes, Congress did recognize that, and came up with a few permanent exceptions. And so there was one for security testing, one for encryption research, one for interoperability and so forth. But there wasn't one, let's say, for the testing of the Volkswagen for purposes of determining that they were committing this enormous fraud on, consumers around the world. And the idea there is that a person, presumably, whether it was, Consumer Reporter, whoever who would hopefully be able to do that kind of research would buy the Volkswagen, right? They're not going to steal the Volkswagen. They're going to buy the Volkswagen, and then they should be able to do the testing of all sorts about how the software in it works. But a lot of that is not covered by existing exceptions in the DMCA. And moreover, there is this whole generation of, yes, there are hackers and there are people who do various kinds of testing sort of in the gray areas of the DMCA. But a lot of people just have decided that it's not worth it. It's not worth the risk. And in yesterday we were hearing about how, there's this whole, you have a lot of academic researchers. I mean, you have some who are willing to get into this area of encryption research and all the other kinds of hacking technologies to figure out how, let's say, Volkswagen gamed the system and to detect those kinds of problems. But if you're working at an academic institution and you know that there are colorable legal issues or there's a potential legal issue and you have to worry about funding, people just don't go into that area of research. It's just not worth it. It's hard enough to get published in tenure to have to worry about the legal issues on top of it. So I think, there's, again, as more software is included in more things, there's all kinds of problems in that software, whether it's consumer protection issues and safety issues that are not covered by exceptions. And to rely on the exemption process to hope that every 3 years maybe an exemption will be granted to cover whatever you want to do is simply not sufficient to take care of the enormous problems that we could fix probably by relatively simple changes to the DMCA, narrowing its scope a little bit.
Thank you. I think Ms. Green was next.
So I was really going to say a lot of what Mr. Brand just said with regard to the fact that the current permanent exemptions are not sufficient to encourage or allow the types of security research that is needed. And there is a chorus of security researchers who will and have said the same. I would also just say that because of the obstacles posed by the rulemaking process and the fact that you have to go through it because the default is no, that serves as a further chill. The last note that I would want to make on this point is that when I was speaking to the public safety concerns and the public health concerns that not being able to have as robust security research as we might otherwise have, I was not suggesting that that's an equity that it is appropriate for the Copyright Office to weigh. In fact, it is our position that the inquiry should be limited to whether or not the proposed use would constitute an infringement. And so we do align ourselves certainly more with Public Knowledge's position on that point. I was merely making the point that by expanding the inquiry beyond whether or not a proposed exemption would constitute an infringement, does in fact implicate significant public policy concerns negatively. And then the last thing that I would note is the idea of access being this threshold and this important protection. When we keep hearing this from industry, it is sort of like the industry trying to have its cake and eat it too, because oftentimes, while there are certain industries that are able to protect their products, as the gentleman from ESA previously stated, there are other industries that simply can't and that still want to rely on limitations to access under 1201. And a good example of this is a study conducted by Columbia University, which found that at some point 46% of Americans engaged in some form of piracy. So clearly piracy is still a significant problem, as many industries themselves say, yet the study also found that the vast majority of those individuals wound up purchasing more digital products online legally than those who never engaged in piracy at all. And so I do think that there are some really interesting findings there that it would be worth thinking about in terms of the value of limiting access.
Thank you. So we're just about at the time, and I see a couple of other cards, and I just wanted to ask one more question. So in your responses, you might I invite you to address this in your responses as well. And that's the question of how prevalent, in your experience as practitioners, is it for 1201 to be used for what you might regard as anti-competitive purposes or to enforce 1201 against consumer products. On the one hand, we've heard that, well, you have the Chamberlain and the Lexmark cases. Those are several years old, and in any event, the courts rejected the plaintiff's claims in those cases. On the other hand, we've heard that in any event, there still is a chilling effect by the prospect of litigation in these areas. So it would be helpful for us just to have your perspective sort of on how commonplace these sorts of claims are in the 1201 context. And I think Mr. Dow was next.
So I guess...
forgive me, we urge everyone to be brief because we're right up against the clock. Thanks.
So in response to your question there, my own firsthand experience is that there's not I don't have firsthand experience with a lot of that type of activity. What I see in that area is largely anecdotal. I see it raised in the context of the rulemaking proceeding. I also see a rulemaking proceeding where, as you said, I think there were 27 exemptions asked for and 22 granted in the last round. And so I'm not sure that process isn't working. I mean, it was intended to be something that could be flexible and respond to these things. And in my experience, I'm not sure that it isn't. I had my 10 up really to respond to Mr. Panjwani's notion that access was not intended to be separate from the rights of the copyright owner. I mean, that notion just simply isn't correct. It was very clearly discussed, very clearly contemplated at the time, and I just wanted to highlight, just coming out of the House Judiciary Committee report, where they say the technological measures such as encryption, scrambling, and electronic envelopes that this bill protects can be deployed not only to prevent piracy and other economically harmful unauthorized uses of copyrighted materials, but also to support new ways of disseminating copyrighted materials to users and to safeguard the availability of legitimate uses of those materials by individuals. It absolutely was not limited to protecting access for the purposes of preventing infringement. It was protecting access for the purposes of incentivizing these new business models, many of which don't rely on exercises of the rights of the copyright owners. In our business, those are the new business models that we're engaged in. We've got a whole suite of apps that allow you to gain access to our linear television content, whether it's Disney Channel or whether it's ESPN or whether it's ABC, to allow you on your iPhone to watch those things on the go. That is controlled, the access to those things is controlled through authentication to ensure that you have permission to have that access. But it's not contingent upon the exercise of the rights of the copyright holder.
Thank you. And quickly, please, Mr. Panjwani.
Just responding to your question about the prevalence of 1201 claims against sort of consumer activities and pro-consumer activities, I would note that that's in part asking for us to prove a counterfactual, in that it's our perspective that the existence of, if we assume that many people are law-abiding and the law prevents engaging in pro-consumer activity that would be prevented by 1201, then that activity just isn't out there. I think we have seen the examples that did come out are involving, the inkjet printers, and I would point out that we filed to clarify that legal ruling to make sure it extended to 3D printers, and that attracted a voluminous filing by Stratasys, a major player in the industry, opposing that on the ground that, no, we have this right to lock you into our first-party filament. And most recently, another competitor of Stratasys, 3D Systems, just announced end of life of one of their printer lines, which had lock-in of first-party filament. And I think that underscores the importance of exemptions like this and sort of the effect that 1201 has.
Thank you. Mr. Pierre-Louis.
I promise to be brief. First, I think it bears repeating that 1201's been a success story in what it aimed to do, right, in the twin goals of both getting more broadband out there, getting more devices innovated, and getting works online and on devices. So it's been a success, and so we've got to really think about how we tinker with it, right? There are two types of tinkerings here, right? And we've got to be very careful in how we approach that. The other is that we've seen innovation really blossom. It hasn't been chilled. And what businesses like is certainty, both in what they can and can't do. And when they know that they can make that investment and get a return, they will invest more, and they've done that. And I think that's been proven out. And so we've got to be careful in how we think about the exemption process and all of those things. But I think first and foremost, we've got to look at this as a success story that we want to continue.
Thank you. Mr. Weisenberg?
Well, I'm not a practitioner just yet. I'll be graduating in a month and passing the bar. But I would again put your attention to the TracFone reply comment from last year's triennial. They do a great job of listing all the success they've had using the DMCA to protect their anti-competitive lock-in model. Again, we emphasize that's not appropriate. That's not an appropriate use of 1201, and we urge the Copyright Office to make a statement, a clear statement, saying that no longer has a place in this process. So, thank you.
Thank you. And I think we'll wrap up with Mr. Band.
So I know Donald Trump thinks that unpredictability is a virtue, but when counseling clients, unpredictability is not good. I mean, not my unpredictability, but the unpredictability of the law. So after the DMCA passed, sort of looking at a plain reading of 1201A, it was pretty clear on its plain reading that it could be used anti-competitively. And I had to counsel clients, yeah, you can't, if you try to circumvent for this purpose or that purpose, to keep competing in the aftermarket, you might have a problem. And then along comes the Chamberlain v. Skylink case, and I said, okay, well, silly me, I was just reading the plain language of the statute, and obviously it means something different from the plain language, but that's good. I like Chamberlain better, and so now you can compete in the aftermarket. And then along comes MDY and says, and they said, no, Congress meant, the plain language controls, and this interpretation of Chamberlain is wrong. And so now I have to tell my clients, oh, well, you used to be able to compete in the aftermarket, now you can't compete anymore in the aftermarket. And so that's where we are now. That sort of depends where you are. I guess in the Sixth Circuit you can compete in the aftermarket, in the Ninth Circuit you can't compete in the aftermarket. And just to, as Raza said, and the gentleman here said, you just have to look at who is opposing exemptions to see how it is being used anti-competitively. So we see in the 3D context, the 3D printer context, it's being used anti-competitively in the track phone case, and then of course, when all the major automobile manufacturers are opposing it because they're basically, it's clearly they're opposing the competition that would be enabled. So it's quite obvious that it has the potential for enormous anti-competitive implications.
Thank you. I think we have to leave it there. I apologize. Thank you to all our panelists. We're a little bit over time, so if I could ask that we limit the break to 10 minutes, if panelists on session 2 could plan to be back by 10:50, that would be great. Thank you.
This has been a presentation of the Library of Congress. Visit us at loc.gov.